Emily Compagno joins us right now, attorney, former NFL cheerleader on all these latest developments. Wendy Patrick is here as well, trial attorney. Ladies, thank you both for coming. You know, Emily, I was looking at this and where the case is going, and Weinstein trying to say that this is essentially a pile-on, wants to save himself, if not his company. Legally, can he? Or is it beyond the beyond right now?
It's beyond the beyond. I find it absolutely ridiculous that he is attempting to challenge this right now. Now, it's true that California courts especially are loath to find contracts invalid. They do want to preserve it intact. However, they're not going to find their support behind a preservation of something that is essentially a crooked intent. Here, that clause to protect him essentially would render him immune to anything short of an indictment or charges. He's arguing here, oh, there were no allegations post-2015, but that's totally irrespective of the fact that the board can terminate him for intentional misconduct. Now, granted, it could go to a mediator or an arbiter, but no one is going to find in his favor because, again, the intention was to render him immune, essentially, from these illegal allegations. That's totally corrupt, and the courts will not stand for it.
You know, Wendy, I was talking to a lawyer over the weekend who was telling me his argument will be that he didn't do anything as extreme. That's he's going to say that have been even the rape allegations. But that what he did and you know, trying to pick up women and all the rest was well known. They joked about it on award shows. It was the kind of stuff that was Hollywood fodder for which he was well known. Nothing was really new here, and all of a sudden they're piling on here unfairly, unjustly. Does he have a legal argument to make here? Because it's so difficult proving a lot of this stuff.
That's exactly right, Neil. The board chose to fire now, answer questions later. And they did that. They took 3 days to decide what kind of a public statement to put out about exactly why they were firing him. And here's what they said. In light of new information. Now, that brings us full circle, doesn't it, to the what did they know and when did they know it provision. Remember, this contract has a crime fraud exception. Now, it's true that while he's been arrested, tried, and convicted in the court of public opinion, not so yet in a court of law that may be coming. But was it fraudulent? In other words, they claim not to have known, as incredible I know as some people think that seems, of what was going on between Mr. Weinstein and some of these victims. If that's true, then they were allowed, according to the contract, to fire without first going to arbitration or mediation, because, Neil, that last provision is what is at issue, according to Mr. Weinstein.
Got you. Emily, another thing I saw and heard, and maybe you can help me with the legal parameters here, is that his contract almost had this abuse built into it. I heard since that was not the case, but that because he paid a lot of these women off in surprisingly small sums over the years, but he did, it was not as if he left the company on the hook for any of this. It was his payments to these women that seemed to indicate, and again, I have not seen the contract, maybe you people have, it would exonerate the company and exonerate him. What do you think?
Well, there are a few arguments here. So first, in the state of California, if there is intentional misconduct on the part of a board member, then he can be held personally liable in addition to professionally liable. So you're right that the board might be able to argue that separation and that they took the steps of mitigation of terminating him. But the counter to that is that the HR department of the Weinstein Company investigated 2 of those settlements alone. So that goes to what Wendy was saying, where it might not be as plausible that they have this deniability. However, if they did reasonably rely on a false statement on his behalf that he made to them concerning these payments, then yes, they do have a case that they were materially misled and thus it led to fraud. But the bottom line is the company's assets have totally tanked. We're headed for a fire sale. So all of them are basically on the hook. And in terms of his contribution to it, he is the one that's on the hook personally for the decimation of its assets.
And he is the very definition of the company. So out or in, I mean, It means the company's future is problematic. Let's switch gears, if you don't mind, ladies. And Wendy, I want to raise this with you. Of course, the big dust-up over Colin Kaepernick now filing a grievance, claiming the NFL owners colluded against him, that because of the kneeling during the national anthem thing and all, that he has become sort of like a hot potato. And all the owners sort of agreed not to hire the guy because of that. Now, other football fans alike have told me, no, it has nothing to do with that. He's just, you know, not a great quarterback. And that was the reason. If he were an exceptional quarterback beyond just a good backup quarterback, for which he might be considered, they'd happily endure the controversy. But he's not. What's the case?
Well, Neil, you're right. You call him a hot potato. He is a radioactive hot potato right now. But that is not what is at issue with this grievance. What's at issue is whether or not there was collusion. In other words, is the failure to sign him coincidence, or is it a conspiracy?
But
So,
wouldn't
Neil
that
and Emily,
involve, I'm sorry, Wendy, just to be clear, wouldn't that involve all the team owners talking or, about, hey, don't even try to sign this guy? That would be so blatantly colluding that they'd almost wince at even the phone call, wouldn't they?
Well, they only need two, so it doesn't need to be a listserv or reply to all situation. Only two, or one team conspiring or colluding with the NFL.
But what would count as collusion? Just saying, don't hire this guy, it's not worth it, you're just going to have more trouble than it's worth?
Interfering with his ability to be employed. Because remember, he's not even been able to practice with the team. So there's the issue of optics and evidence. It looks bad, but does that mean that that is circumstantial evidence proving that degree of collusion? It's an uphill battle. I know Mark Geragos, he's a great lawyer, but he has his work cut out for him because that's going to be a tough standard to prove.
All right. I hear, Emily, that there are far less talented quarterbacks among the 89 or so that are either lead or backup to the backup quarterbacks, and surely he would fit in that group. And the fact that he's not is curious. What do you think?
People have made that argument. What's important here for viewers to know is that you need to have hard evidence of this case for a case of collusion to stick. Now, in the grievance, it was totally vague. It didn't reference hard evidence at all.
What is hard evidence, though? What would you need as hard
existence.
evidence?
Emails, notes, actual audio, something between two or more teams that allude or cite specifically, yes, we have agreed not to hire this person. Now, instead, in the grievance, they cite, again, vague directives by the NFL owners not to hire him. They cite that they succumbed to President Trump's comments, and they say that it's
two or more, so you could get away
impossible.
with as few as 2 or 3 teams, and that would be collusion, even if the other 33 or so had no part in it.
Correct. That is enough for the clear preponderance of the evidence, which is the standard here. Note the grievance cites a statistical impossibility that he's not hired. But what's also important for the viewers to note is that that's not all football is. It's not relegated to only statistics. So you're right, as you just stated, that there are quarterbacks that have less impressive stats than he does that are employed, but they are evaluating the player as a whole. And so unless there is specific evidence, again, as to collusion, it could be simply that he was that radioactive hot potato that you cited, and no one wants to pick him up.
Is that a justifiable reason to say, Colin, as talented as you are, we just don't want to deal with the grief in hiring you? What do you think, Wendy?
Neil,
Absolutely.
It is if you've got
Owners,
the teams.
Yeah. Okay, Wendy first.
If you've got the teams acting on their own, and that's the issue here, and Emily raises all the right points, is if the teams came to that decision of their own accord without consulting or agreeing is what you'd need with the other teams, it's all good, even though he hasn't been hired.
Emily?
Right, absolutely. Everyone has their own choice to hire as long as it's not with collusion and some type of evidence. Again, I find the optics here totally curious, and frankly, I think it is just for optics that he's filing right now. Again, the language of the grievance, it cites his social platform. It does not cite evidence.
All right, just to be clear, though, on that point, Emily, then if I'm saying no to Colin Kaepernick because I don't want the grief, talented though he might be, I don't want the grief and the controversy in my stadium because I can ill afford it, especially now. Am I doing anything wrong? Am I being unfair to him? I certainly haven't colluded. I've established that on my own. He's not worth it.
You are not doing anything wrong. The collective bargaining agreement specifically states that if a player brings an injurious behavior, if it in any way decreases the value of the team, if it affects the relationship between the team and the public, any of the above, it's your prerogative. In fact, if he's already employed, you can actually terminate him. So you can totally decide not to hire someone that you see as a divisive player because it might bring down the value of the team, or more importantly, the camaraderie that the team depends on to win games.
All right. Thank you, guys, very much.